Thank you very much, Mr Deputy Speaker. It's my great pleasure to rise and speak on the Competition and Consumer Amendment Misuse of Market Power Bill 2016 and place on record my strong support for this important reform. And, Mr Deputy Speaker, this is very important reform. The bill before the Parliament today to amend Section 46 of the Competition and Consumer Act 2010 is all about standing up for small business, is all about ensuring there is a level playing field, and is all about ensuring that we do not continue to see the sort of anti-competitive conduct dominated by the likes of Coles and Woolworths, which have in many respects served to squash or diminish small businesses. And, Mr Deputy Speaker, we have seen some dreadful examples, and where was the Labor Party? Where was the Labor Party in standing up for consumers and small businesses when we saw shocking conduct by the likes of Coles and Woolworths in demanding unlawfully, improperly, I say a sort of corporate corruption, frankly, demanding rebates from their suppliers that were designed to push suppliers to the wall? And what we are seeing from the Labor Party is, yes, the status quo is fine. Mr Deputy Speaker, the status quo is not fine. We are incredibly proud. This is just rubbish what we've heard from the member speaking before. As a strong Liberal, I'm very, very proud to stand up for this reform. The Coalition is very proud to stand up for this reform, because we have seen in Section 46 a provision that is not properly working. The Harper Review recommended strengthening Section 46 of the Act after finding that current misuse of market power law is not reliably enforceable and does not effectively target and deter anti-competitive conduct to the detriment of Australian consumers. So what the government has done, Mr Deputy Speaker, is adopt a recommendation from Harper, who did a superb job, I have to say, and I want to put on record that very important point, to create a commercially and legally robust law to prevent firms with substantial market power engaging in conduct which harms competition in Australian markets. This is not about preventing a large supermarket chain from discounting, and what we've heard from the member opposite in the previous contribution is just rubbish. This is about ensuring that whether you are a big business in this country or whether you are one of Australia's more than 2 million small businesses, which make up more than 97% of all businesses, that you can operate as a business on a level playing field. The reform Section 46 will prohibit a corporation from engaging in conduct with the purpose, effect or likely effect of substantially lessening competition in a market in which it directly or indirectly participates. As the Treasurer Scott Morrison stated on the 1st of December 2016 in his media statement, he made it very clear that the new provision will more effectively address anti-competitive conduct, protecting the process of competition rather than individual competitors. He said these reforms represent an important step towards ensuring Australia's competition laws are fit for purpose and support competition in a dynamic economy. They are a key part of the government's response to the Harper Review, which is all about increasing choice and delivering better services and outcomes for Australian consumers. So, Mr Deputy Speaker, this has been, over a long period of time, a pressing issue in Australian competition law, supported very strongly by the ACCC. And I have to say, Chairman Rod Sims, leading that organisation, is doing, I think, on balance, a very, very good job at tackling these issues of failure to comply with the law when it comes to competition law. and I think has led the way, along with the likes of Professor Alan Fells and, of course, Professor Harper, in illustrating and demonstrating that this is no longer fit for purpose. So what this reform does is modernise the competition law by simplifying it and by strengthening the protection of small businesses from economically harmful, illegitimate, anti-competitive behaviour by big firms with market power. And as we know, this is done by the introduction of an effects test. The economic case for this reform is extremely strong. No other country, except New Zealand, allows monopolists to harm competition. So this is what the Labor Party is supporting, a proposition where if you have a monopoly or a duopoly in the case of the large supermarkets, that you can conduct yourself in a way which harms competition in the market. And I say that because the misuse of market power provision was simply not working. The threshold was too high. It was simply too onerous for a smaller business to go to the court and argue that there had been a breach. But what Professor Harper has done in recommending this change is he's recommended a reform which ensures that there will be a continuing protection of legitimate competitive behaviour, which is why I say to members opposite, it's just absolutely wrong and improper to argue that this will prevent some sort of healthy discounting in the market. And history will, I think, prove me to be correct on that important point. It recognises that the line between competitive and anti-competitive behaviour is not drawn by having a purpose test, but by having a proper economic test. Now, we know that this is opposed by sections of big business, but it's strongly supported by small business, farmers and consumers. And I do want to reflect on the contribution I made on this issue some time ago, back in, I'm just looking for the date, sometime in the last year. I apologise, I haven't got the date. I'll find it in a moment. When I spoke and congratulated the 20 industry bodies calling on our government to amend Section 46. And let me just mention some of these bodies, all coming together to say the current law is not working. And as I mentioned when I started my contribution, Mr Deputy Speaker, we've seen some terrible examples of abuse of competition law from the likes of Coles and Woolworths, which basically, almost frankly, tried to blackmail their suppliers by demanding improperly rebates. And some of the conduct has been terrible. Of course, Coles and Woolworths have had the legal repercussions, and in Coles's case, in fact, it incurred a fine of some $10 million. We will not tolerate this, Mr Deputy Speaker. We will not tolerate a legal system which allows this to happen, and where the law requires strengthening, we will firmly stand behind all businesses, big and small, to ensure that we have a robust market. And that is the essence of a free market. Not protecting the big boys, not protecting those who've got the power. The essence of a free market is in protecting competition and in standing up when there is anti-competitive conduct in the market. And I just want to reflect on the alliance of bodies which called for reform. So it is just simply not true that most voices are against this reform. The Australasian Convenience and Petroleum Marketers Association, the Australian Chamber of Commerce and Industry, the Australian Booksellers Association, the Australian Hotels Association, the Australian Retailers Association, Australian Dairy Farmers, Australian Newsagents Federation, the Hairdressing Association, the Commercial Asset Finance Brokers Association, the Convenience and Mixed Business Association, Fresh Markets Australia, the Central Markets Association of Australia, MGA, Independent Retailers, Independent Contractors Australia, the Motor Trades Association. The The list goes on and on. The current provision is simply not working, and I want to put on the record that I consider it to be disgraceful that the Labor Party is not supporting a change in this provision. And we are seeing once again a case of the Labor Party doing one thing, saying one thing and doing another. And we've seen it on the issue of penalty rates, Mr Deputy Speaker. And might I say, I do want to question the Labor Party's motivation. We all know, and we've heard a lot of evidence before this parliament in recent weeks about some of the dirty deals that have been done, where young workers have had their penalty rates stripped from them altogether because of deals between the likes of the SDA union, the Shoppies union, one of the most powerful unions in the country, and the likes of McDonald's, KFC, Woolworths and Coles. There is absolutely no doubt, Mr Deputy Speaker, that Labor, metaphorically, is firmly in bed with these large companies, and I find it a disgrace that the Labor Party is not prepared to stand up for fair competition and not prepared to stand up for our farmers, our consumers and small business. So how ironic is it, and everyone in this parliament knows, everyone knows, Mr Deputy Speaker, that the Labor Party have been doing these deals, and that's why, Mr Deputy Speaker, they're not backing this reform, because they are in bed with the likes of Woolworths and Coles and other large employers, and that's why, Mr Deputy Speaker, we have introduced our Corrupt Benefits Bill, because we have heard much evidence in this parliament in recent weeks about some inappropriate payments, Mr Deputy Speaker, that have been received by unions, which just coincidentally happen to occur at the same time as these EBAs have been negotiated, EBAs which have left young workers at McDonald's receiving something like $26 an hour on a Sunday with no penalty rates whatsoever, and other businesses and other workers being paid at least $10 more an hour. So that's what the Labor Party is doing out there in the workplace, dirty deals in conjunction with unions like the SDA, and this is the result. So we need to look behind what the Labor Party is saying tonight in this debate, and we need to see their motivation. Mr Deputy Speaker, I make the same point on multinational tax avoidance. Again, a case of the Labor Party saying one thing and doing another. Another failure by the Labor Party to stand up for those big multinational companies who were ripping off Australians, who were ripping off Australian workers, and it's an absolute disgrace that the Labor Party has opposed our measures to combat multinational tax avoidance, again backing their mates. And frankly, I know, and we all know in this parliament, there is a great deal of embarrassment by Labor members that they did not support that particular bill, which has now resulted in our government collecting $2 billion in tax liabilities from multinationals, which has come from a range of sectors in the energy, resources and e-commerce sectors by the Australian Taxation Office. So when we hear about hypocrisy, look no further than this Labor Party, Mr Deputy Speaker, a Labor Party that doesn't have the guts, doesn't have the courage to stand up to the big boys in town and say enough is enough. And as I say, we did not hear those voices when Coles and Woolworths were systematically ripping off hard-working men and women who had spent a lifetime building up their business. And even after that conduct, even after they'd been caught, even after they'd been fined, even after they'd paid their penalty, there was still, I was getting complaints into my office, there were still stories going on of suppliers being told what they had to do and not do when it came to repaying Coles and Woolworths with their sleazy rebates. So I say, on behalf of the Turnbull government, I am very proud of this reform. This shows we are determined to stand up for all businesses. This shows we're determined to stand up for jobs, and I commend this bill to the House.